Good morning and welcome to the Law News Network. I'm Jesse Weber. Thanks for joining us. Okay, I want to give a rundown about what we've covered yesterday and what we can anticipate today. So yesterday we saw now the break in the Morris brothers trial. This is the trial of Boston Celtics forward Marcus Morris and his Washington Wizards forward Markieff Morris. They've both been charged with 2 counts of aggravated assault, which are felonies in Arizona. The brothers are accused of beating up Eric Hood outside of a Phoenix gym in January of 2015, and they not only face up to 4 years in prison, that would be towards the maximum, but if they're found guilty, they also face game suspension under the collective bargaining agreement. The NBA. What you saw yesterday was the prosecution's closing argument, the defense's closing argument, but those closing arguments are going to continue Monday. We do not have a live feed in that, but we are going to analyze it here today. But more pressing, and what we expect to have live coverage any minute, is the case of Florida v. Frank Bybee, this strange and very disturbing case of a former Bybee, who's a former Sarasota County Sheriff's deputy. He's been charged with 18 felonies, including attempted murder, exploitation of the elderly, burglary, theft, and kidnapping, and he faces a life sentence if he's actually convicted of the first-degree felony charge for attempted murder. And who is it of attempted murder of? An 80-year-old woman named Marcia Souls. Now let me explain this story because it's so outlandish, but it's pretty crazy, so let me explain it. Miss Souls, who, as I said, is 80 years old, or 79 at the time of this incident, called the sheriff's office for help on October 21st. Bybee, a patrol deputy, was sent to the call and took the woman to Sarasota Memorial Hospital, where the former deputy prayed with her before he left. About 2 months later, the woman reported that Bybee had inserted himself into her personal life and had become too controlling. One of the things that he has been accused of is manipulating her finances. And basically taking money from her. She asked the sheriff's office for help in ending their relationship. Bybee was placed on administrative leave, and 3 days later he went back to the elderly woman's home and attempted to kill her. That is what the accusation is. Well, now these charges have been brought against him. These are very serious charges, and what we saw yesterday, what you see right there, is the victim in this case taking the stand, and that was very, very compelling testimony. It's all about her, and really this case is about her because, as unfortunate as it is to say, she is an elderly woman, she is infirm, she is in a wheelchair, and the question is, will a jury believe what she has to say? Because the question became under cross-examination, does she remember everything entirely accurately? There's been questions about maybe she was supposed to be, when investigators were reported to her house, they thought things weren't exactly as they seemed to be. She wasn't making sense. They even said the crime scene looked staged, and maybe she was pointing the finger at Bybee. Well, there's a lot of questions in this case, and I think we need some answers. So before this trial actually begins, and again, it is supposed to start any moment, we have with us criminal defense attorney, former prosecutor, and former Georgia State Representative LaDawn B. Jones. LaDawn, thank you so much for joining us again here on Law News Network.
I'm so excited to be with you.
Great. So let's talk a little bit about this bizarre case. I want to start with Marcia Souls taking the stand. You have probably seen how she did up there. Many people have been saying that she clearly didn't want to be up there. I believe she testified for over 5 hours over the course of 2 days, and when she was finished, she was so relieved to get off that stand. If you're a juror listening to her, are you concerned about what she saw and heard, and is she accurate?
Well, you know, although she is an elderly woman, she was able to testify in a way with details that made it clear she was there. What makes it difficult for victims to testify in this case is that they are reliving again and again the instances that occurred that led to them being at trial. Imagine most people have not even been in a courtroom, much less on a stand, preparing to be cross-examined with 6 jurors staring you in your face, trying to decide if you're telling the truth or telling a lie. This witness was able to give enough details that corroborated everything that the state said that they would present in the case that I think she was very credible to the jury. Frankly, it's one of those scenarios. What would she have to lie about? She had no purpose in lying. She gains no benefit from lying. The fact that she did not really want to be on the stand, and that was obvious, is a high indication to the jury that she clearly is here because something serious occurred.
I mean, there was so much to dissect from her in her cross-examination, her direct examination, the idea that she has issues with her memory. She kept repeatedly being asked, do you have issues with memory? And she said, not more than any other 80-year-old, but it seemed to be there were certain things in her testimony, in what happened during the course of these events, that couldn't add up. We're a bit later the testimony of Sergeant Jonathan Allen, who actually went to her house, and he said that the crime scene looked staged. She said that she had been involuntarily committed to a mental health facility for 14 days. That didn't seem to make sense. So again, the question becomes, what is the jury supposed to believe with this woman? Obviously, something strange is going on with this guy, Bybee, and her. It's a very weird relationship, and they're trying to make sense of it. But again, the question becomes, do you believe her?
Right, and so one of the things I think that was very successful with his defense is that, you know, they made her look like an eccentric woman, right, who may have kind of concocted all of this stuff in her head, that she was trying to create a relationship with Bybee, and she was upset at how the relationship turned out. They were successful in finding little loopholes of things that were a problem in her direct testimony, questioning her on times and locations and dates, things that they knew that she couldn't remember, and highlighted those things, while at the same time kind of glossing over the direct testimony, where she was able to give some pretty accurate details about when Bybee came to see her. She may not have known dates and couldn't testify to exact dates and times, but she was able to describe very clearly the details of him visiting, him repeatedly coming back to her house, the access that he had to her, and then in particular the portion where he came into her home and communicated with the doctor, explaining that she was trying to commit suicide. I mean, it's truly, as you described it, a bizarre case, and the facts being so bizarre opens up the door for the defense to just make the jury believe all of this is made up.
Well, let's talk a little bit about what some other witnesses testified. We saw Soul's neighbor, Sheila Stiles. She said, I noticed the bruising. I wanted to get into the injuries, because it's alleged that Frank Bybee went to her house, was wearing blue gloves, tried to kill her, smother her. And I think at one point they described it as a physical battle between Bybee and this 80-year-old woman, which again doesn't quite make sense. But again, there was bruising. According to Soul's neighbor, Sheila Stiles, she says, I noticed bruising around her mouth, the swelling, and specifically that had been bleeding. It wasn't bleeding at the time I saw her, and the blood on her nightgown, but due to the swelling, had she fallen or hit herself or something, the swelling appeared to me that it was from a hand pressing down pretty hard. The swelling would not have been like that were it not inflicted, in my opinion. Now, having said that, when Sergeant Jonathan Allen took the stand, he said it very well could have been that the cut on her lip was chapped lips, and he only noticed a little blood on her gown. How's a jury supposed to reconcile these two forms of testimony?
So, you know, what a jury would do in this case, and I don't recall the profession of the next door neighbor, right? But a general person has a hard time telling if an injury came from a hand versus some kind of blunt object or falling out the bed, for example. So those details, although it may have been convincing, the neighbor has nothing to gain, the neighbor's not directly involved. Can a neighbor really tell the difference versus a police officer who sees injuries on his day-to-day activities and has seen some pretty severe injuries, being able to tell a serious laceration versus what could have just been a chapped lip? You know, the extreme nature of this case will make a jury believe that maybe the neighbor is filling in the blanks to make the story sound more realistic. And what a juror usually looks at is, you know, what does the person testify to? How is their demeanor? How are they sitting in the courtroom? How clear do they remember the evidence? And the judge will give them instructions for that at the end of the trial when they have to determine the credibility between the two testimonies that seem to conflict.
It's what we do know, if you're a juror sitting there was some sort of relationship, there was some sort of connection between the victim and the defendant here. The question becomes, what was the nature of the relationship? Who decided to end it? And I'm not, when I say relationship, I'm not suggesting anything past what we know. I'm just saying there was some sort of bond between them. There was something going on. So the question becomes, when did it end? Who wanted it ended? How did it happen? Because in one account, you hear someone saying that Frank Bybee said, when the woman reported on him, he goes, I'll take care of it. I'll take care of it. At the same time, you hear a message from about this woman, the victim, that she said that she needed Bybee to be done away with. in a way, a jury is looking at this and saying they both wanted to end it, and who do you believe? Now, is there the fear? Is there the problem that really you look at these two people, this is an elderly woman, this is a man much, in prime physical peak of his life. You have these two people. Who are you going to side with? You're going to side with the victim in this and maybe not take the facts into account. It's an issue of jury nullification or something like that. Isn't that a fear?
It definitely should be a fear because, there's no better witness to have on the stand than someone's dear old grandma, right? Those are the best type of witnesses that the state would want to put up because they carry about as much credibility as the natural credibility that a jury gives to a police officer, any law enforcement or person who is sworn to uphold a duty. What's odd in this circumstance is unless Frank Bybee's attorney could lay out circumstances where he's done this before, right? He's just such a caring police officer, and all of the old ladies on his beat just happen to know him, and he comes by and he visits. Without additional proof of circumstances like that, it kind of weakens him because why this particular woman? You meet victims and respond to calls every single day as a sheriff's deputy. So why this woman unless there was something else there that seemed not to be true? Now, equally so, depending on what the evidence can show, did she continue to call him? Did she push for the relationship to move forward? All of that leads up to who actually ended the relationship based on who actually pursued the relationship. Was it an equal amount of contact where she was calling him to come over? I mean, just the number of visits alone that they discussed. It's just odd in this circumstance after the initial call that led him there.
And LaDawn, you and I both know that there's situations where people take advantage of elderly people for a variety of reasons, including money. I mean, there's really, one of the things he's charged with is, let me get the exact wording here. He's been charged with exploitation of the elderly. So is it possible, I was thinking about this, that this guy, he's charged with 18 felonies, he could be acquitted maybe on the attempted murder charge. Maybe there's too much back and forth about whether or not he really went over there to kill her. But this is a guy who was controlling her was intimately involved in her finances. He was maybe taking advantage of her. He could be charged with those other crimes, maybe those personal fraud crimes. But the attempted murder one, maybe that's a little bit too much of a stretch.
It may be, and so depending on who's prosecuting the case, there's two ways they go about it. Sometimes they throw everything to the wall and see what sticks, right? Starting high with an attempted murder charge makes it easier for all the other charges to seem reasonable in case the jury decides to compromise on their outcome. It makes the seriousness of the case just seem grow so much more by having that additional charge. But the evidence as it was testified to is not really a whole lot there to say, was he really attempting to kill her? I mean, maybe assault, right? You may have proof of that if you believe the neighbor and the witness about the injuries and you believe the victim about how the injuries occurred. But actual murder may be pushing a little far. There are laws in Florida and all throughout the United States that specifically protect people who are 65 and older. And they do that because of their particular vulnerability in these particular cases. I would be interested in knowing if Bybee was ever tried to friend another elderly person who he was not aware with. I mean, to take on financial involvement with her bank, involvement with her finances, asking her questions about her income and where her money comes from. All of those things are extremely odd, again, for this type of relationship where he first met her from responding simply to a call.
Makes no sense. They had no relationship. Wasn't a son, wasn't related to them in any way. I mean, it makes no sense that they would have this sort of relationship. Then the flip side of it is, if you want to take it the other side, this is a guy, he's an officer. He saw this sweet old woman, wanted to take care of her, maybe realized that she's entering the twilight of her life, wants to take care of her, wants to help her. Maybe she reminded him of somebody, and there was nothing nefarious going on. And then you could have a woman who either A, maybe really wanted to point the finger at him and get him out of her life, or maybe she just misinterpreted what was going on. The idea of, I thought he was coming over to kill me, maybe she misinterpreted it. There's just so many ways to look at this that I think right now it's a difficult job for a jury to try and make sense of.
It is, but then you have to look at what we would consider circumstantial evidence of all the other factors that went into this relationship. If a police officer was going and met someone on their beat that they felt was someone they cared about, they would reach out to their colleagues, right? Hey, there's a lady over here who I really want to help. Do we have clothes, or do we have food, or whatever her needs are, right? You reach out on social media, if you're on social media, saying, hey, I would like to help this person. Or you at least have a track record of getting this involved in someone before. He is missing that in this case. And so it makes it really odd now. On the flip side, there was a lot of testimony that the victim didn't have a whole lot of family or people around her, right? Which makes her the perfect victim, but it also makes her the perfect person to need and want to have that kind of attention and continue to call Deputy Bybee to come over and help her and communicate with her. But, at the moment when she reports it to the police, to the other deputies there, that is a clear indication that she did not want this kind of relationship, right? Had she never gone on her own to report it, then we would say, okay, well, maybe she's just kind of missing what happened. But she, in fact, reported this crime, reported what was going on, and what was crazy is that the law enforcement department just told him and let him handle it, which, only increased the likelihood that he was in fact trying to defraud her in some way.
I think that "let me handle it" statement is really probably will be his downfall if he is convicted in this case. We are talking so much about the victim in this case, Marcia Soul. Let's actually show some of her testimony from yesterday, and then LaDawn and I will actually analyze how she was as a witness, which we talked about at the beginning. But this is the victim taking the stand. She was now an 80-year-old woman. I believe she was 79 when this whole event took place. But take a look at some of her testimony, how she behaved. Again, she didn't really want to be on that stand. So you take a look, and we'll be back here with more analysis.
Kill me.
The last time frame that you recall being in your house was what time?
In the neighborhood of midnight.
And your recollection of the time that he arrived?
Somewhere between, it was dark, it was winter though. Somewhere between 7:30 and 8:30.
All right. You would agree with me that that's 4 to 5 hours. Is that right?
Yes, sir.
Does that help you calculate how long, according to you, he was in your residence?
Objection. Asked and answered. How long does this
Objection,
go on?
Judge.
Ma'am, I'm going to ask you not to make comments such as that. I believe it has been asked and answered, and I will sustain the objection.
Thank you.
How long did you stay in your house that day? Do you know?
From the time I came home,
Until when?
days.
All right. When you would agree with me that you were taken away sometime in the evening of January 12, 2017 by ambulance. Is that correct?
I was taken away sometime on the 12th or the 13th to the hospital for a checkup.
And how long did you stay there?
Hours. I do not remember that it was in an ambulance. I think I was driven there.
Did you stay overnight at the hospital?
No.
When you say, well, tell me what they did to you at the hospital.
The normal checkup.
Did you have a chest x-ray?
You're kidding.
Ma'am, did you have a chest x-ray?
I don't remember.
Okay. Did you have a CT scan?
Nurses,
Were you familiar?
techs, etc.
Were you familiar with them?
None of them.
Your doctor, Dr. Lerner, did not see you while you were in the hospital. Is that fair?
I believe that's true.
Did you eventually go see him once you were released from the hospital?
You mean that day?
Whenever you were released, ma'am.
No.
I could just have one.
Mm-hmm.
No further questions.
Thank you.
We're finished?
The state has the opportunity to ask you some questions as well, ma'am, so. Shirley?
Ms. Sewell, do you remember what time you took a shower after Frankie Bybee attacked you?
No, I have no recollection of doing so, sorry.
Do you have a memory of calling the police that morning?
Yes,
Do you have a memory of what time Frank Bybee came to your house on the night of January 11th?
sometime between 7:30, 8,
Why are you so sure about that time?
because I would be watching a program or news.
Okay. Is that a guess? Or are you telling the members of the jury that you can accurately pin down that it was between 7:30 and 8:30?
No,
I
I,
want you to think about that before you answer it.
I can't remember the name of the program, or if it was news, it was CNN.
All right. So you have a lot of memory gaps about when Frank Bybee came over to your house on the 11th. Do you have a lot of memory gaps?
I don't think so.
Well, some of the questions that the defense attorney asked you, you responded, I don't remember. Let me ask you this. Do you have a clear memory of Frankie Bybee coming to you with blue gloves on his hands and covering your face with his hands and trying to smother you while you sat in your blue chair and struggled for your life?
Asked and answered, improper.
The stage.
Do you have a clear memory of Frankie Bybee trying to shove pills down your throat?
Asked and answered.
Sustained.
Do you have a clear memory of waking up?
Objection. Asked and answered. May we approach?
Ms. Fradley? Ms. Fradley, you can't get a redirect and the witness a position and ask her to agree with that position. She's already testified as to what it is. She's testified both in direct, she's testified during cross-examination. I don't see why we need to go through the testimony a third time in front of this jury. All right? Thank you.
Do you give money to everyone, Miss Sewell?
No,
Do you give money to a lot of people, Miss Sewell?
charities mostly.
When you say charity, what do you mean? You mean actual institutions that
The girls'
Solicit-
club,
Okay. Do you go around giving out checks for $65,000 to people?
no,
Did you give Frank Bybee your credit cards?
no,
Okay. And did you allow him to sign your name to credit cards?
no,
Did you tell him to take $400 out of your account almost every day when you were at the Sarasota Memorial Hospital and Consulate Health Care?
no, ma'am.
Objection. Asked and answered.
Oh,
May I have a moment, Your Honor?
you may.
Now, you were asked about Johnny Drew when the defense attorney was talking to you, and do you remember who Johnny Drew is now?
Yes, I do now. I thought it was a man originally.
Okay, well, let's talk about Johnny Drew. Did you ever give Johnny Drew any money except for giving her your credit card and asking her to provide groceries for you?
I paid her.
In addition to the work that she did for you.
Did I give her money?
Yeah, did you give her money?
No.
Anything else? Nothing further.
You may step down. Thank you very much.
I'm out. Thank God.
Welcome back to Law News Network. I'm Jesse Weber. You were watching the victim, Marcia Soul, testify in the trial of Florida v. Frank Bybee, this very strange and disturbing case of a former Sarasota County Sheriff's deputy who's been charged with 18 felonies, including attempted murder, exploitation of the elderly, burglary, theft, and kidnapping, as well as several other fraud charges as well. If he's convicted of the first-degree felony charge for attempted murder of that 80-year-old woman you just saw testifying, he could face life in prison. A lot of questions going on in this case, trying to make sense of it. Here to help me make sense of it, and as we analyze it, is criminal defense attorney, former prosecutor, and former Georgia State Representative, LaDawn B. Jones. LaDawn, thank you so much again for being here. We were just watching the victim testifying, and as we were watching this, just to give a little bit of context to what's happening in this case, the relationship between Frank Bybee and the victim here, the relationship originated when Bybee went to her house to respond to a call that she put forward. He gained her trust by taking care of her dog. He was reportedly paid to take care of this dog, but then he ended up selling it on Craigslist. Then there were checks from the victim with his fingerprints on it that were made out to him, and then he tried, as the story goes, allegedly tried to kill her a few days later. So the jury's listening to all of this, and this woman's taking the stand. She's in a wheelchair. You've had witnesses on the stand. You're seeing this. This is all playing an impact. This is all playing an impact for them. And at the end of the day, it's not looking good for Bybee.
Not even a little bit. So, what the defense tried to do in that last clip you played was show that her memory is not so great. But he could not really point out that it was not so great on items that are relevant to the case. She couldn't remember if she saw the doctor that day or a different day. But she could very clearly remember what her daily schedule was, that at a certain time she watched television. The state was able to firm it up to say, how do you know? Which is something you do when you're preparing your witness to take the stand, is you help them to identify the important factors to connect their timeline, and so that they can show credibility to the jury about how they know what time things occurred. Although her memory is clearly an issue, there are certain things that either she completely is hallucinating about, or her memory is clear enough to show that there was a direct connection with Frank Bybee and her that she did not want to continue after a certain point.
Well, obviously, things that she's saying are true. I mean, he's admitted to taking money out for himself, but he said he did it took control of her credit cards, but he did it for her benefit. So there are things that she's saying that he's backing up that are true. She obviously faced some sort of injury. She had lacerations on her lip. There was blood. The degree of this struggle might be a question. She said that Bybee broke into her house, mounted her, and forced prescription medication into her mouth. According to her testimony, I tried to get away from him, and I kept trying to get away from him, and kept expecting to see the white light you see when you die. I mean, that's terrible and tragic to hear, but at the same time, you have a 79-year-old woman against this full-grown man. It doesn't really add up if you listen to that.
Absolutely. And I mean, 79, it depends on who the person is, their health and their history, but we've had two people run for president, that were in the same age group, right? And these folks are very spry, and they know what has happened to them. You do not create a fictional story of someone trying to stuff drugs down your throat just because, right? Frank Bybee as a law enforcement officer who has had to investigate cases of fraud, where he's called to a scene and say, someone stole my checkbook, someone stole this, would know better than to cash this woman's check without some kind of paperwork, something that says that he is now her financial, attorney of record, right, or power of attorney. He knows better, and his connection with the law is just enough to say, if he did all of these other things, how can we presume that he did not physically attack this woman, as I said? And again, I agree with you. I think that it's a bit of a stretch for the attempted murder, but for the assault charges, certainly there was more than enough evidence to show that he, or her testimony alone, in addition to the timing of the injury. I mean, the only other excuse for her injuries is she tried to hurt herself, right? For this whole story, and it just doesn't make sense.
Yeah, it could have, I mean, the only other aspect that they tried to put on her is that it could have been an accident. She could have fell, something could have happened in that way. But it doesn't add up when you put in everything about, I mean, look at this timeline. I mean, he made checks from the victim to himself with his fingerprints on it. He's clearly writing money out. And then it was only a few days later that this alleged attempted murder happened. So again, there could be a situation where he's found guilty across the board. You could have a situation where he's acquitted on everything. Maybe the jury really doesn't believe he had any kind of involvement, or something in the middle ground where he really is convicted of forgery and the grand theft and burglary, but the idea of that attempted murder just goes beyond the line, because really you were taking one person's word over another. And when you look at the physical evidence of the crime scene, you see the condition that she was in, the degree of the struggle that she described might not add up. And in a moment, I am going to play the testimony of Sergeant Jonathan Allen, who describes this crime scene, and it describes a little bit about what he encountered, how it might not add up. But before we do that, LaDawn, I do want your thoughts on that point.
Well, now what you're talking about is the ability that juries, or the problem juries have to have, which is determining the intent of a person. We can't get into the mind of someone, right? And so we have to determine or argue intent based on the other circumstantial evidence that's around. His intent could have very much been just to knock her out, right? And steal all her stuff. And I have not seen enough evidence presented that can get above the intent of maybe an assault or a theft to actually rise to the level of murder. There's not been any testimony of witnesses that said that he had this plan. He didn't have, trash bags and things in his back seat of his car, or other indications that the intent was actually murder. And so I agree with you. I think that is going to be the major problem that the state will have in this case, because there's just not enough to rise above that line to allow the jury to presume some type of intent based on all the testimony that's been presented. And
then again, if this really is, as we believe it to be, that he tried to make it look like a suicide, you are going to try to attempt to show that there is no struggle. So she's not going to have the kinds of lacerations or blood around, because if it looked like that, it's not going to work out so well. So maybe what really happened was, her description of a struggle really is he was trying to force that medicine down her throat, but in a way that made it look, trying to not have any of his evidence in the crime scene, but try to do it in a way, I'm going to have to force the medicine down her throat, but in a way that is not as aggressive and as maybe she's describing it, but maybe it really did happen. So that's what we have to see. But to add to that complexity for the jurors to understand, let's play Sergeant Jonathan Allen's testimony, and then when LaDawn and I get back, we're just going to briefly touch about the Morris Brothers trial, which we covered yesterday. It's going to be resuming on Monday with closing arguments, continuing of closing arguments. But now, let's look at Sergeant Jonathan Allen, and we'll be back here to talk more about this case and Morris Brothers.
Have you completed?
Yes, ma'am.
Just for clarity of the record, it is 16A, correct, not 6A?
Yes,
I just want the record to be clear on it. It's 16A as opposed to 6.
All right, so after having read what's been marked and admitted as State's Exhibit 16A,
Well,
what,
it hasn't been admitted yet.
It has not been admitted.
after you read After you read what has been identified as State's Exhibit 16A, what did you do?
I continued with my investigation. Like I mentioned before, I felt the scene was safe. Now I was more concerned about the victim.
Objection to the victim.
Sergeant, would you see the soul as opposed to the victim?
Yes, sir.
Thank you.
Okay. Did you notice any injuries on Miss Soul?
I did.
Could you please tell us what you saw as you observed her?
She had a small laceration on her lip, and there was a small amount of blood on her chin.
And did you come to learn that Ms. Dobro took photographs of Ms. Soul while she was there?
I was not aware of Ms. Dombrow taking photographs.
All right. I'm going to show you what have been marked. And admitted into evidence of states 4A, 4B. Look at those for me, please, sir.
Yes, ma'am.
Are those photographs a fair and accurate reflection of the way Ms. Soul looked when you were at her home around about 5:30, 6 o'clock on the morning of January 12th, 2017?
They do, minus the amount of blood that I don't see that on these pictures here.
Okay, so
On her
are you
chin.
saying that the blood has been somehow wiped up or disappeared?
Yes, ma'am.
But other than that, do those photographs fairly and accurately reflect her appearance when you were at her home at 5:30 or 6 o'clock?
That's correct.
Thank you, sir. May I publish these?
You may.
The trickle of blood that you described to us, can you tell us on which side of her face, in the soul's face, that you saw that trickle of blood? If you can remember.
I can. It would be towards her right side, in that shadowed area.
I'm going to give you a search to show us.
So, very thin line from the corner of her mouth down her chin.
Was that the nightgown that you described as having blood on it?
That is.
Now I'm going to show you Exhibit 4B. And once again, that's the state of Miss Soul when you saw her arrive at your house.
Yes, there's a oxygen tube that initially she had in her nose.
And when you saw her, was the oxygen tube still in her nose?
Yes.
And can you see the trickle of blood in this photograph?
No, ma'am.
When you left the scene, what was your take on what had occurred at 3296 Brockton Lane?
I felt it was a mental health issue
And why is that, Sergeant?
for a number of reasons. The first being that she said she was in a mental health facility for the past 14 days
Yes.
and that she was there not of her own free will. which at that time did not make sense to me.
Okay, I want you to speak up nice and loudly so the jury can hear you. So,
She said she had been in a mental health facility for 14 days against.
Yourself.
Okay.
So I asked you the question. The more you talked to her, her story changed, correct?
Correct.
And in your interview with Detective Gaeta, Sergeant Churtliff, back January 12th of that year, that's exactly what you told them, right? It's right there in the paper.
Correct. That's what I said.
That's what you said.
Mhm.
All right. Now, you called rescue and asked them to come to the scene, correct?
That is correct.
EMTs, correct?
That is correct.
All right. Just give me a second. Don't read any further. And I'll refer to that in a second if we could. Did you actually see EMTs rescue arrive?
Yes.
Did you see them go in and interact with Miss Soul?
I was outside of the condo,
Yes, sir.
and I watched them walk in, and I watched them come out.
How long, in your estimation, were they in there evaluating Miss Soul?
I would say less than 5 minutes.
You have no idea what was asked or what they did. Is that fair?
That is fair.
Okay. Now, just to be clear, you were one of how many sergeants that were on scene that morning?
I was the only sergeant.
Okay. How about Sergeant Fields? Did you see him?
I did not see him.
How many other deputies were there?
Total of 3 deputies and myself.
3 deputies being who, if you recall?
I do. There's a Deputy Carson Blank, Deputy Russ Reynolds, and Deputy Chris Butler.
And then yourself, correct? But you did not see Sergeant Fields.
I left prior to his arrival, but he didn't show up.
All right. Who was the very first deputy on the scene? Do you know? And if you don't, that's okay.
I honestly don't. Me and Carson Blank arrived simultaneously.
Do you recall that when you arrived, other deputies were already there?
There were no other deputies there.
All right, fair enough. Talking about injuries that you saw, if any, on Miss Soul, you mentioned that she had a very minor abrasion to her lip.
Correct.
You did not see bruising throughout her face, correct?
That is correct.
You did not see bruising on her neck, correct?
No, I did not.
You stated that you saw pills scattered, I think you say, underneath her chair?
Yes, sir.
Did anyone collect those pills?
No, sir.
Your impression, Sergeant, was that Miss Soul, at the time that you were there, at the time you interacted with her, appeared to you to be delusional, correct?
Some type of mental health event, correct.
And in fact, it was your impression, after talking to her, looking at the scene, was that it looked staged. Is that correct?
That is correct.
You were made aware by Miss Soul that, according to her, Mr. Bybee sat on her chest, but you didn't see any real indication of trauma, correct?
She mentioned specifically initially that he was sitting on her chest, but that his knees were more in her pelvic area, and I was not looking.
Let's be fair, you didn't check that area.
I didn't check that area.
Okay. So, if in fact there was trauma to that area, you didn't do anything to visually verify it?
Yes, sir.
Okay.
That's correct.
It was your impression, Sergeant, that in speaking to Miss Soul, she gave indications that she both loved Mr. Bybee and hated him at the same time. Is that fair?
That is fair. That's where I think the story kind of changed.
And you said in viewing her nightgown, or whatever you may want to call it, there was, quote, a little bit of blood, correct?
Yes.
And you were concerned because the description that she gave you of a 2-hour physical battle between her and Mr. Bybee, what you were seeing of her physical presence didn't support that, correct?
That is correct.
And in fact, I think you described what you saw on her lip as just maybe chapped lips, correct?
I believe so.
When she was asked about whether she ingested any of the pills, you recall that she would say yes and then no, and then yes and then no.
That's another part of the story that vacillated and changed, yes.
Do you know whether she was transported to the hospital?
I know she was not.
Do you know why?
I do not.
We have a moment.
You gotta open the little door on the front.
Sergeant, I'm going to show you a photograph. Very good. You see this area here, bruising on the nose, bruising on potentially the throat area. You didn't see that.
Can I take a look at the actual?
You looked when you saw it, correct?
Welcome back to the Law News Network. I'm Jesse Weber. Thanks for joining us. We were watching prior testimony in the Florida v. Frank Bybee case, a very weird, strange, disturbing case. We've been analyzing it all morning, and helping me to analyze it is criminal defense attorney, former prosecutor, and former Georgia State Representative LaDawn B. Jones. LaDawn, great to see you again. I just have a question as we were watching this. We were watching Sergeant Jonathan Allen testifying about what he saw and heard of the victim when he reported to her house. Now, he's not a mental health professional, and he's testifying to the fact that she has some sort of in his opinion, some mental health issue. Now, is that appropriate, or couldn't the argument be that under the Baker Act, which allows someone involuntary commitment of a person with a mental health issue, he had a right to be there, make a judgment, or is this totally inappropriate?
Well, I think law enforcement in general, when they go to a scene, they have to evaluate all of those things simultaneously. Is someone injured? Are they in their right mind? Are they under the influence of alcohol and drugs? So that's a normal thing for law enforcement to be able to, or that they're required to evaluate. So it's not inappropriate. But here's the difference. In this case, he knew that he was arriving to a scene where a fellow law enforcement officer, someone who I believe was in the same department with him, is being accused of a very serious crime. And as you've mentioned, a very weird crime, right? And so immediately the police officer is listening to this. He's hearing this woman's testimony, but his bias has to kick in immediately, right? If this woman is reporting that one of my fellow officers, who I know, who I see on a regular basis, has done this very outlandish crime, and this is before he knew that there was financial ties, this is before he knew that he was taking care of his dog, his first presumption is likely, this woman sounds crazy. And he went with that and ran with it. So although I think it is appropriate for him to have attempted to evaluate, the jury hopefully will be instructed not to ignore his inherent bias. Just any person, even if he didn't work with the officer, hearing the story immediately and then seeing the victim and how she speaks, right? She sounds like an elderly woman who may not remember or know everything that she's speaking of. All of those factors combined is something that the jury will have to consider, but I really think that bias that he would have is going to outweigh his perception on the scene.
And let's not forget, this guy also said that he thought the crime scene was staged. He said that it was possible that the laceration on her lip was merely chapped lips. So that the jury's going to hear that, might resonate with them. I think we've done a pretty good analysis so far of what we know in the Frank Bybee case. I do want to shift gears a little bit with you, though. I want to switch gears to the Morris twins trial. Again, this is the trial of Boston Celtics forward Marcus Morris and his brother, Washington Wizards forward Markieff Morris. They've both been charged with 2 counts of aggravated assault, which are felonies in Arizona. The brothers are accused of beating up Eric Hood outside of a Phoenix gym in January of 2015. They face prison time as well as game suspension under their collective bargaining agreement with the NBA. Now, LaDawn, what we saw yesterday was the closing arguments, or the beginning of the closing arguments, with the prosecution and the defense. Prosecution is saying, listen, you cannot say that this is about money, that the victim in this case wanted money, because he didn't set up that attack. He was the one who was the victim here. He got beat up, and it just so happened to be that the people that did it were the Morris twins, and they happen to have money. So don't blame the victim in this, blame the 2 people. Was that a compelling argument?
It was, until you saw that the victim's story changed. The victim initially went forward and said that it was both brothers. And then he came back and said, well, one brother was in the area and in the vicinity. That's a huge difference. Either 4 people jumped on you and beat you up, or 2 people who have already pled guilty and admitted to their involvement with it were involved in this fight. And so it starts to make you wonder, I get it. In the sense of someone jumping on you, you may not be able to directly count everyone who's involved. But then you also don't come forward and say, these 2 guys in particular were those who jumped on me. I think that there is a good argument there for an extortion scheme. Either pay me out, or I'm going to bring criminal charges and then sue you civilly.
Right. The prosecutor said that Marcus Morris was the one who kicked him in the head, but it was Markeith Morris who acted as an accomplice, and under the law, that's why they both can be charged for the same kind of crime, the aggravated assault here. But I thought the defense did a tremendous job. I thought they did a terrific job, and we're going to be seeing the continuation of that closing argument on Monday, but they were doing a great job of basically saying, these two witnesses are unreliable. The two witnesses, first of all, Eric Hood's unreliable, and the girl that he had taken to that basketball game, who he really didn't know, but he seemed to had the beginnings of a romantic relationship with, she's unreliable. She liked him because their stories didn't match up, and her testimony didn't match up to what was really in existence. So when she was describing, I remember that part of the, I remember that part of the area. I remember seeing that. I remember seeing that. I remember seeing that. Well, that wasn't around when this event took place. So already, if you're the jury, you're saying, not so accurate. You also have a guy who was being beat up by multiple people. What he saw and what he heard, he's discombobulated. And the general trend, what we saw from the defense was saying, we know the Morris twins were out there. We know that they were in the area. But everybody was saying that they weren't involved in the fight. They were just near the area. Do you agree that the defense did a good job?
Absolutely. The defense did an excellent job. The points particularly on, this girlfriend that was with the victim or date, those are the kind of witnesses you want to bring because they lack bias, right? This wasn't her long-term boyfriend. She doesn't have a reason to lie for him. They wouldn't go in together with some kind of scheme for money together. So, of course, she's reliable until you realize that her testimony had to be manufactured. That they had to go back to the scene and say, okay, this is what's here. And then, to have such a striking memory on something that didn't exist completely undermines all of her testimony. And the defense bringing that out and even being able to, that's what you get when you get $1 million defense, right? Mm-hmm. is an attorney that has the time to go back to the scene and put the pieces together to say that this awning or this whatever was not there at the actual time that the incident took place. That was truly remarkable work.
Yeah, I mean, witness after witness after witness was coming forward and not pointing the finger at the Morris twins. And when you hear that, I think there's enough reasonable doubt to get them off here. I don't see it happening. And remember, these guys are not only facing prison time, they're facing game suspension, which hurts their wallets, which hurts career. That's what's really why this has taken so much of an interest in the public, because obviously assaults happen all the time, but you have two professional basketball players, twins, in this very strange case where a guy, he's saying he had a relationship with the Morris twins. They're saying they didn't have a relationship. Obviously there was some relationship. And what stemmed all this? A text message from the victim here, Eric Hood, to the mother of the twins. Let's talk about that text message and the motive. What do you make of that?
For me, when I heard about the text message, I just presumed that this might have been fandemonium, right? Someone who really wanted to be a part of these superstar basketball player twins' life so that they can insert themselves, right? And when they were ignored, when he was left out of the conversation and could not continue after reaching out to the mother, is a pretty good indication that he may have not been being completely true. He wants something else out of both of these guys.
LaDawn, I know we have to let you go, but I want to hear your final thoughts on the Morris twins case as we head into Monday, where we're going to hear our closing arguments. Do you think that we're going to hear a verdict soon? I mean, once the case closes and it goes to the jury, do you think that we're going to it's going to take them a while to deliberate, or are you going to see a quick verdict? And what do you think that might be?
So I always struggle with verdict times, because particularly when you're in the courtroom, your client's next to you, and they're like, short means it's good, right? Wait, no, long means it's good, right? So it's very difficult to tell. I think that the defense did a very good job at creating doubt in this case, and when they finished summarizing and putting together all the facts, I believe that's going to help. I would expect, I know for the one twin where all of the evidence showed that he was not directly there, I think we're going to find a not guilty. I am not so certain about the twin, just because the jury may, again, compromise and say, well, we know something happened, and the evidence is pointing to the fact that at least one twin might have been involved in kicking him in the head. So I'm not so certain that he will have a complete not guilty on that case. I guess we'll just have to wait and see.
Well, LaDawn, we will wait and see, and as soon as we have a verdict in that case, maybe we'll have you back on to talk about what you think of it, one way or another. So LaDawn B. Jones, thank you so much for joining us, and we'll make sure to have you back on soon to talk about this.
Thank you so much.
Thank you.